Good morning. I'm Lauren LaFlamme with Bearing Insurance, and welcome to our SESCO webinar on how to conduct internal investigations. Presenting today is Joe Cullum from SESCO Management Consultants, and we've partnered with SESCO for many years. And since 1945, SESCO has provided human resource and employee relations consulting throughout the country. If you're a client of ours, we encourage you to take advantage of your access to SESCO. A little housekeeping, this webinar is being recorded and I will share the recording with everyone at the conclusion of the webinar. And we will have a question and answer session at the end. Please make sure to place your questions in the chat feature as you think of them. And with that, I'll turn it over to Joel Colum, Senior Vice President at SESCO Management Consultants.
All right, can you hear me all right? Lauren, we good?
Yes.
All right, gang. Thank you for having me today. I'm here to conduct a session on conducting an internal investigation. I am casual in my approach. I'm going to give you a little background on it. We'll talk about what we're going to talk about, and I'll try to leave time at the end so we have time for a detailed conversation. But just real quickly, I know that Lauren introduced me. I am Joel Cullum. I am actually based in Bristol, Tennessee. We have an office in Richmond, Virginia, with many of y'all may know Jamie Hasty, and I'm actually covering for her, but this is a topic near and dear to my heart. I've been with the firm, it'll be 29 years this December, and I'm the one that conducts investigations, whether they're EOC charges or internal investigations, or assist clients in doing so. So I have a pretty good grasp of this. I won't get into SESCO since Lauren talked about it, but just know that I have some qualifications here. And then finally, just kind of an overview of the program. We're going to talk about some background, the internal investigation itself, maybe how to conduct interviews. There's a little bit more to that. I'm going to give you some statistics, some understanding of just what the EOC charge looks like, and and then just kind of wrap it up. So again, if you want to count slides, we're doing 50 slides. And I may interject some stories and some thoughts here and there, but I will keep an eye on the time. Okay, so it is important. Importance of investigations. Why is it important to conduct an investigation? Well, at the end of the day, it's all about the legalese. Provides defense if the employer took reasonable care to prevent and promptly correct any harassment. And we say harassment, we also need to think about discrimination. I've been discriminated against in the workplace, a little bit different than harassment. So it is important that we understand how to conduct internal investigations. You can conduct these on your own. You do not need to reach out to legal every time unless you have a large organization in this process. Okay, just some reasonable care, and we're going to provide some tips on how to walk through that process. Okay, so if the employer has an adequate policy and complaint procedure, but an official failed to carry out his or her responsibility to conduct an effective investigation of a harassment complaint, the employer has not discharged its care to exercise reasonable care. So I've got a little slide over top of this. It's duty to exercise reasonable care. The EEOC, one of their basic premises in this is that you need to ensure such behavior does not reoccur. When it's harassment, ensure such behavior does not reoccur. And part of that process is conducting an investigation and then ensuring it will not reoccur. They have a pretty simple guide on that, and it's a good statement to consider as we move through this. Okay, so good investigations save money. Here's the part that we like to scare you with, but there are some pieces here that are important. Litigation and lawsuits have increased over 400% for the last 2 decades. More than 40% filed against employers with 15 to 100 employees. So employees don't care whether you have 5 employees or 500. They will litigate, even if they're your friend at times and they're a longtime employee. Almost 24% filed charges against larger organizations, 500 or more. 16% chance that the award would exceed 1 million, 67% that it will exceed 100,000, and average compensatory award in federal court is almost 500,000. It'd be interesting to see what state courts are, because that number is probably even higher. So we're just giving you an idea of the cost here. I'm actually going to talk to you in a little while about what the reality is in the workplace of charges being brought. Okay. So a good investigation helps. It can assist in staff distraction, stress and discomfort, reduction in employee morale. So these are the things that you have to worry about when somebody internally says, I got a problem with Joe Smith over there. And I hope I don't have Joe Smith on the call, but I have a problem with Joe Smith. He did this to me, and I've told other people about it. All of a sudden, we've got employee morale, we've got distracted people. We potentially, this is the big one that I get more recently over the last 5 years, is social media damaged reputation. What if this gets out? How do we manage that piece? And, we work with other organizations that are very employee sensitive, like funeral homes and car dealerships and the like, that this may be their number one issue is what their perception looks like or their reputation looks like. Uh, do we perpetuate bad practices? That's what good investigations help with. And successful lawsuits breed more lawsuits. So a good investigation will shut that down. So just those pieces, there's a lot of intangibles here, but are we doing the right thing? Are employees looking at us and saying, how are they going to handle this? Are they doing the right thing? And so it's important. Okay. So the goals in investigative procedures is promptness, obviously. We show reasonable care to prevent future misconduct. Confidentiality, we'll talk about this piece, decreases the fear and likelihood of retaliation, and thoroughness and impartiality. Inspire employee confidence that they can come to you without being retaliated against. Okay, that we are a fair and equitable organization. So we want to be timely on these. We want to try to treat it as confidentially as possible, not always the case, and we want to be impartial and thorough. Okay, so important considerations that we look at in investigations is, when do we need to investigate? What's our obligation to investigate? Is this kind of complaint an investigation or is it just a conversation? The timeliness of the investigation as quickly as possible. Is the investigation adverse action? Will somebody see this as that we're taking adverse action? So we need to be impartial in the process so it doesn't feel that way. Do we suspend somebody without pay or with pay to send them home while we investigate? I work with a number of long-term care communities that do these things. They'll send people home without pay, and at the end of it, if you're not guilty, then you'll get your back pay. Okay. Effect on employees' request not to investigate. Employee says, please don't investigate. I just want you to know about it. Well, obviously, we have an obligation to investigate, even if they say that. And then finally, the big one is who conducts the investigation. If you have competent individuals in the organization, they have some experience with it, understand employment law, i.e., the HR department, then they should be able to do that piece. If not, there are other activities where you could involve SESCO just to say, can you be our coach on the sideline to walk through this, which is not uncommon. Here's what we're doing. Here are the questions we're asking. Here's the scope of the investigation. And then you can reach out to counsel as well and say, should we get an attorney involved? And I typically see attorneys involved in high level matters where it's senior management or there's been a report to the board of directors about somebody in senior management. And that's when they'll get a third party in. So it may be political at times, but that's when you get the third party in. So a lot of things to consider. Okay, so when to investigate. So when any information comes to light from any source that relates to potential violations of the law or company policies, this can be a traditional complaint where they come to you, write it up. It can be a hotline. It can be just gossip. It can be, I heard an employee talk about this, and we might need to go down the path of where there's smoke, there might be fire. And you have an obligation to conduct a thorough investigation and document your findings and actions. And I'll stop on this point. When to investigate? Your timeline for an EEOC charge is typically less than 1 year. If something occurred more than 10 months ago, and I'll get into this later, but if it occurred more than 10 months ago, you're free and clear. They can't file a charge based on time. But what happens if an employee comes to you and says 3 years ago, John Doe sexually harassed me, or they were a bigot and said some nasty things that were racial? Do we have an obligation to investigate? I'm going to tell you internally, I think you should, even if all the players aren't there, just to show that we had due diligence, even though there can't be a suit. But if we have a practice or pattern in our organization, that we need to be aware of. I would go back 3 years. I'd go back 5 years if we can do it, just to have an internal confidence that we're doing the right things. Sorry. Investigative file, you want to set up a separate file. You remember investigative relation documents are discoverable. This is emails, this is notes, this is comments, this is texts, which I see so much of. They can all get in front of a jury. So always think about that you have to retain all these things. They can make or break a case. And if you copy attorneys, which that's really going down the path with it, it can then be subject to attorney-client privilege, where some of this may not be, some of your emails that's corresponding with attorney would be protected from being discoverable. Yeah, that said, I mean, I went through a case in Ohio in the past week where the text sunk the case before they even got started. Ownership and branch managers denied that there was any conversations about harassment in the workplace when the employee and employees could prove they reached out and were told that they weren't going to do anything about it. So this is all discoverable. Okay. So let's start talking about the internal investigation. I got a number of steps here. I think there's 9 of them, but just these are all bullet points for you to consider. First thing's confidentiality. We got to do the best we can to protect the confidentiality of employees' claims, but it's not always possible. If an employee says, I want it confidential, well, if you're going to have to interview one person and that becomes a spider web of 3 more people because they have information, it is what it is. Okay. Now, with that said, we are going to ask those that are potential witnesses to keep it confidential, professional, not get it into the grapevine. So, and they are obligated, those witnesses are obligated as a condition of employment to cooperate. And that's a whole nother discussion, but what if they don't want to cooperate and they've got information, then we may be looking at policy issues with that employee. So, but we will keep it as close to the vest as possible. But I've done where I've had 28 subpoenas in one organization. Pretty tough when they have 100 employees, and I've interviewed a quarter of them. Okay. Provide interim protection. We talked about it earlier. Step 2. What do we do to protect the victim or alleged victim? Do they need to go home? Do we need to send them to another department? That doesn't look like it's adverse action. We could send them home without or with pay to protect them while we conduct it. It depends on the parameters of each case stands alone. So it depends on the situation. Do we need to change the transfer? You get the idea. Do we send the alleged accuser home while we conduct this? So again, case by case, what's the the validity of it? A lot of things going on here, but we do have to protect, period. Can they both sit side by side while you're going through an investigation? That's not what we need to do. Step 3, selecting the investigator. I hope in your mind's eye within your organization, you might know who that is. But if you don't, then that's when people kind of tend to reach out to either counsel or SESCO or whoever you may use. But they have the ability to investigate objectively. They don't have a stake in the outcome. They do have some knowledge and investigative authority working in this, and they have strong details, strong skills with talking to people, and they are respected. Confidentiality is a must. So a lot of moving parts there. So that's why third parties typically might get asked on something more serious, because it shows an absolute objectivity. Okay, sorry. So create a plan is the next piece. Okay, now we've got this in front of us. We think we've got our investigator. What's our approach? Who's been involved? Who's been linked to it so far? What's our plan with regards to timeline, when we're going to schedule interviews and the like? So that's where you develop the witness checklist, sources for information and evidence. Do we need to pull personnel files? Do we need to look at emails? Do we need to get IT involved? Do we have cameras that we need to review? So there's a lot of pieces here depending on the situation. So the interview questions are really important in this process. And of course, we've talked about retention of documentation. So have it planned out. Does it need to be, on an Excel spreadsheet with this, that, and the other? No, it could be simply kind of typed out. Here's what we did. Here's what we're going to do. Day 1, this is the approach. And hopefully we can do it in a day or two, depending again on the case. So plan for it, develop your interview questions, and I'll provide you kind of an overview of that. And since this is being, copied, you'll be able to take those questions that as they show on the PowerPoint and actually develop your interview. But you have a complaint interview. Even though they came forward, we really want to go through a formal interview with them. They may have given you a written statement, but we're going to have to go back to it. The accused employee interview, and then the third party witness interview. Now, I'm going to tell you on this note, people say, when should I interview the accused employee? If I have corroboration and I know I can get more than one person that will corroborate what has occurred, I like to have the witness interview second when I go to the accused employee on this, because it may not be a matter of I didn't do it, but we've corroborated it, and it's why did you do it? What were you thinking? And the like. So it's one thing if it's a he said, she said, or she said, she said, that kind of thing. But it's another thing if we can get our ducks in a row before we go to the accused. Now, certainly if we're sending the accused home, we need to let them know that they're under investigation. We may not even report to them what the complaint is yet, but they need to go because we've had a complaint, and we'll provide them more information as we move along, and they'll have an opportunity to address it. Okay. So types of questions recommended. I got a couple slides here, and really you do go through the basics of who was involved, what occurred, when it occurred, where, who did it, what happened, who else heard it or saw it is big. When did it occur? Has it stopped? Where did it happen? How often did it occur? You get the idea. How did it affect you is a different question. How did you react? What was your response when it occurred or afterwards? That gets into a personal feelings about this. But the last one is kind of important. It starts giving us a gauge of the veracity of the complaint as well. Okay. So other questions that we do. Who else knows what happened? So again, we're looking for corroboration. Has anyone else had a similar experience, same or similar experience as you? Do we need to go talk to them? Are there any notes, documents, or physical evidence that you're aware of you could provide? They may say, listen, why don't you just look at the tape? I was out in the, in this area that we know, public area that we know has camera. And again, how's it affected your job performance? And finally, the big question for me is how would you like this to resolve? If you're sitting in my seat, Jane Doe, how would you like this to be resolved? And this tells me the veracity of the complaint to some extent. I don't want anything to happen. I don't want an apology. I just want it to go away is one thing. I want them fired. I want money. You get the sense. If you all don't do the right thing here, I'm going to contact an attorney. So that last question is a big one. Okay. Okay. Witness interview tips, and just briefly, you know, advise any witness the importance of telling the truth. Ask appropriate open-ended questions. Again, kind of like what you just saw in the complainant questions. Um, what witness was told by the accuser complained the existential evidence, or sorry, existence of physical evidence, not existential. Others with information, again, what we may again increase our web of interviews. Does anybody else beyond the complainant? And then the next person has somebody else that would also be able to discuss it. So, and then finally, discuss the importance of confidentiality and its limits, and make sure you listen. So we're going to go into all of these, even though we know that the complainant may be suspect, and we're going to talk about that. There's the credibility of the complainant, and the timing of the complaint comes into play. But we're always going to take the high road and treat it, if it's somewhat truthful, we're going to treat it as though they're our best employee. Okay, and be impartial. All right, steps to take in the internal investigation is conduct the interview. Inform all parties involved of the need for an investigation, the urgency of confidentiality, explain the investigation process to the individuals, focus on being impartial and objective, as I've mentioned already twice. And the investigator, meaning one of you all or one of your designees, should never offer opinion or say anything to interviewees that will discredit his or her impartiality. We don't start gossiping about things during the interview. We're going to keep it very, very buttoned up and get through it. Okay. Okay, so I don't like the term interrogation here. It's more plan the interview. Preparation pays. So just reminders on the interview. Be nimble. Don't forget to listen and ask follow-up questions. You may have a written script, but things pop up. So pay attention and say, well, can you tell me more about that? Um, Remember, the goal is really to find the truth in this process. Take your time, allow the interview to unfold. And I'm going to come back to that. Remain impartial. So there's the fourth time I've said it. Okay. But take your time. You may find that some of your interviews only last 25 minutes with some witnesses or less. Others may take an hour and a half. So understand what you're getting. And you may only be asking for one piece of evidence from an individual. Did you see it? Did you witness this? Do you have anything to say? And they say, no, I'm really not aware of it. I don't know why you asked me in. Well, then that's going to be a very quick interview. Okay. So understand that you may that it's just going to be vary depending on the individual. The interrogation or the interview of the complainant is going to be lengthy, and the accused should be lengthy. Okay. So again, conduct the interviews. Credibility determinations. That's what I was just talking about. Things to consider when determining credibility. Inherent plausibility. Legalese here, but is it reasonable to believe this could have occurred? Is the person making a reasonable statement that's alleging this? What's the demeanor of the individual? Is there motive to falsify? Well, they just got a performance review the day before that was not bubbly. And the next day they bring a charge and they say the reason my performance isn't good is because I've been harassed in the workplace. So you can see where we're going to here. What is the motive to protect their position? Do we have corroboration of the charge? And then finally, the past record of the individual or individuals involved. So we do look at credibility. Are they just, again, trying to protect themselves? Okay. And I'm not saying to blame the victim, but we need to look at it. And then make a decision. Be careful not to jump to any conclusions before all the facts are available. When any credibility issues have been resolved, the investigator will evaluate all the information for a formal recommendation. The investigator and/or member of management, as well as legal counsel, shall make a final determination of any employment actions that are warranted on the investigative report. The employer must consider all of the parties involved, as well as company processes, not just whether the accused is guilty, in the final determination. So what's the last line saying? It's like, essentially, do we need some better processes for reporting? Do we have good policies in place? Have they been disseminated? There's a lot going on here. Making a decision. What have we done in the past in a similar situation? And is it something that we need to move off of because it's just a new world, new dynamic, or are we consistent with past practice? So making decisions, obviously a big one. And then how do we address it? Can we ensure that the behavior will not reoccur based on our action? Okay. We separated two people. We put them in two wings of the building with different schedules. Or did we terminate? Or is it a slap on the wrist? Or is it providing some training and an apology? Again, all of this is worth consideration. So determining the outcome, possible findings, there's three of them. Well, the conduct occurred, the conduct didn't occur, or we just couldn't prove it. We didn't have any proof. It was her against him against him, her against her, and the like. That said, we still may, if the investigation is inconclusive, we're going to come to the victim and say, listen, if it ever occurs again, you still come to us and let us know. But we're here to protect you. We don't have conclusion in this one. Okay, and the closure of the investigation. Once the decision is made, the employer should notify both the complaining employee and the accused of the outcome. When necessary, obviously take corrective action that is appropriate. Look at any damages incurred by the victim, discuss with legal counsel on how to remedy those. That is a rare event. I've really not seen that when it's an employee working in the organization that they have some type of damage, and determine if education would be beneficial to the individual or employees. So it's not uncommon to do harassment or discrimination training either on a one-on-one basis, or we roll it out to the entire organization because it's been 3 years since we've done it and we want to re-clarify our position on our working culture. Okay. But when it comes to the first bullet point, notifying both the complaining employee and the accused of the outcome, that first piece, the complaining employee, We have some letter format to put a close to it. We can't provide all information to them, and maybe what corrective actions we took because it's an individual basis. So that one has a little nuance when we actually report to the employee. It can be verbal, but some organizations want a written documentation that they communicated the outcome to the complaining employee. Okay. And once the decision is made, the employer should consider if there's a need to review and modify, again, redistribute workplace policies and determine whether review the investigation complaint resolution processes is necessary. So again, to do a post audit, essentially. Okay. And I think I said there was 9 of these. And finally, develop a written summary of the investigation results. The report will summarize in this kind of a format to it. The incidents and issues investigated on this date, these parties came forward with a complaint or party. The parties involved, you would list the employees, the key factual and credibility findings, including sources referenced. Then you note your employer policies that might have been violated. And then your specific conclusions. Did it or didn't occur, or it was not corroborated. Okay. And then you would note who was involved in the scope of the investigation, who was involved in it, when the interviews occurred, who were the investigators, who were the members of management or council involved in this decision, and issues that could not be resolved and reasons for lack of resolution. And finally, the employer actions. Based on all of this, testimony and witnesses and the like, this is the direction we're going based in this case. Okay. So it can be quite a bit there. It can be a 1-page to 5-page report. Typically, I don't like to see a 1-page report, but it could be. Okay. So enact our corrective measures. Discipline should be consistent. Again, let's look back at previous or past history. A punitive warning and expectation of future conduct. We send somebody home without pay for a week and tell them that to get right in their head, and we're going to provide you training and properly document it, even with verbal warning. So we're going to follow our corrective action policies that you already have in place, but make sure we have excellent documentation. Okay. And corrective measure checklist. This really does go to kind of a corrective, any corrective plan outside, whether it's in an investigation or outside with discipline. So date of occurrence, date of disciplinary action, state the reason and facts and specific witness testimony, reference applicable policies, reference any prior discipline with specificity that the employee may have had, describe consequences based on the findings. If departing from a written progressive discipline policy, state why. We're moving to the 3rd tier and terminating because it may be so egregious. And I imagine if you have a 3-step process, we can always deviate depending on how serious a first offense is. Clearly outline future expectations. Allow the employee, the accused, to respond. Have the employee sign the document or note that they refuse to sign the document. Follow up, document whether there was improvement, continuing. It's almost like a PIP plan, continuing failure, and maintain a record of discipline in the employee's personnel file. So you can see this is a little bit beyond just the investigation itself. Okay. All right. So that brings to a close just our internal investigation. And again, just to talk about that piece, if you need assistance, want to walk through it, if ever pops up, it's not uncommon that we get these calls, and it may not take long, but this is our line of reasoning. What do you think about it? And we will engage in that conversation and maybe provide some documents for you to work with. Okay. So the second piece of this is the wheels have come off, and the employees felt the need to file an Equal Opportunity Commission charge of discrimination or harassment against their employer. Okay. All right. Let's talk about this process a little bit. Equal Employment Opportunity Commission, the EOC, they handle all the complaints under the Civil Rights Act, our landmark legislation from 1964, race, religion, color, national origin, gender, right? They also handle, and I don't have it here, as the sexual harassment came in 1972. I should have that listed. So there is a provision for harassment that began in 1972. You've got Title I of the Americans with Disabilities Act as amended for people with disabilities. EOC handles that. They handle age discrimination. If you're 40 years of age or older, you can file a charge. and the Pregnant Workers Fairness Act, which has been on the books since the early 70s. I'm sorry, that was the new one from 2023. Pregnancy Discrimination Act from the early 70s, and the Equal Pay Act, where men and women doing the same job with the same skill sets should make the same amount of money. Okay, but that's what their latitude is here. You're going to see this twice in Virginia, and I know that we may have some folks in other states on this call, but it's typical that if you file a charge with the EEOC, you've got 180 days to file a charge. I was aggrieved in August of last year. Now it's June of this year, and I file a charge with the EEOC. It's going to get kicked out because you didn't file it in a timely manner. That said, if you file duly with the state that you're in, it's typical that they expand that to 10 months, so 300 days. So if there's a dual registration with the state, Virginia Human Rights Commission, and the EEOC, I just tell people 10 months is your window. After that, you're free and clear as an employer. Okay. In 2017, if you've not been privy to one of these, this all goes through a portal. The EEOC will send you an email. They may send you mail to say, get on the portal. And with the EOC charge, and they'll give you a temporary passcode. You change that, and all documents come to and fro through that, which is actually, there's an ease there. Okay, it used to be that you had to get affidavits, they had to be notarized, which they still do, but they need to have originals. And back in the day, we FedEx them overnight to make sure they got to the EOC in a timely manner. So now they accept them scanned online. So more than you need to know, but I'm going to dig in a little bit more here too. Okay, so let's talk about this. The Equal Opportunity Commission in 2024, just statistically, the EOC secured almost $700 million for victims of discrimination in the workplace. I want to put this in perspective. I pulled a slide out from 2019 to replace this to give you current data, and it was about 456 million. Okay, this was a record year in 2024. 470 million in relief from private sector, state and local government through this process, the discrimination process, mediation, conciliation, or enforcement. 40 million was in monetary relief for charging parties through lawsuits, and then 190 million in monetary relief for federal employees and applicants. So the federal government does not get this right. And that's almost double too from the 2019. Okay, so kind of big numbers here with regards to that. Now, with all that said, this is the slide I wanted to kind of share with you and think about this. I think I need to bump it up. And I'm sorry this isn't updated, but this gives you an idea. So look at the very bottom of the slide. 81,000 charges were filed in 2023 through the state or federal government. Okay, all combined. And if I tell people we got 180 million people working in the United States, and what percent of those file charges of discrimination or harassment, people say 10% because it's in the media. Well, I'm like, well, that's 18 million. Well, 1%, 1.8 million. I mean, 81,000 in 2023. It was 88,000 in 2024 for your perspective. Race is what used to be the number one year after year was number one is that the most charges of discrimination. If you look down, way down the list, you'll see that disability, people with disabilities, American Disabilities Act has been number one for the last 6 years. Okay, that is the largest group of individuals in the United States that are I guess protected status group are people with disabilities, over 44 million people. Okay, so we've got race, we've got sex. Now, the 25,000 charges of sex also include sexual harassment. Okay, so it's gender discrimination. I didn't get the job with the police department because I was a female. That's discrimination. I got the job and then they harassed me. That's harassment. Okay, religion makes the news, but it's not that big a deal. National origin, which country, what's my birthplace, what's my origins. I could be third generation, but it's national origin. Skin color, skin tone is actually a charge of discrimination. It's not exactly race in some of our protected communities. Darker skinned people file charges against lighter skinned people. Equal Pay Act makes news, but rarely does it get a charge. Age discrimination. 14,000 in 2008, 2009 when the economy tanked. So again, I've been here for a while. Those went up to over 25,000. People lost their jobs. They got mad. And so charges kind of ebb and flow with the economy. Again, disability, 29,000. Genetic information, which you should never worry about. 361. Retaliation is the number one, and that's a box that you fill out on the form. It says, I told them about I was being sexually harassed, and then they retaliated against me. Everybody marks retaliation. And finally, in 2023, 188 charges of pregnancy. So it's really limited. It goes to the administrative process of an EEOC charge or the Virginia Human Rights Commission. These things are typically handled between individuals or within the organization. Does it occur more than this? Absolutely. We just don't have the statistics on it. Okay, so here's the other piece. So in 2023, there was almost 8,000 charges of sexual harassment. Out of those, 25 on gender discrimination harassment. 17.4% were made by males. So let's not discount that. 1 out of 6 charges year after year are made by males against females and other males. A workplace that is, you've got an individual that goes to church on Wednesdays, Saturdays, and Sundays and Sunday nights, and he works in an environment where it's lewd language with other males. You can expect to get an EEOC charge from an individual like that. And don't be surprised if it's an unprofessional environment. Okay, so let's talk. I'll just pull all these up. There's some numbers to look at here. So this is what the EEOC, this is what happened. So let's think about those 88,000 charges in 2024. No cause finding, middle of the list. That means there was no reasonable cause to believe discrimination occurred. Okay, that's 62%. Reasonable cause, 2.3%. Successful conciliation, 1.1%. I'm going to talk about conciliation. Unsuccessful conciliation, 1.2%. Merit resolutions. So this is where you're guilty. Merit resolutions, 18%. Okay, so that piece. And then under that, it could be the settlement, reasonable cause, conciliation fall under that merit resolution, that something occurred. Okay, administratively closed, almost 19%. Or withdrawn. So it's really a rare event. It's going to be 1 out of 5 that something occurs. And even when it occurs, it doesn't necessarily go to court. Okay. These things can be settled. I'm working with one right now on a conciliation agreement in Ohio about the ones I was talking about, the text messaging. So, rather than litigate it, the EEOC wants to take care of this as the best they can in-house. Okay, so what happens what you don't have a slide on here is what happens if there is a no cause finding or if there's a cause finding. Well, cause finding, they're going to try to work with us to remedy this. And if it's so egregious, the EEOC actually has attorneys that can sue on their behalf or point you to an attorney. But even if you win with a no cause finding charge, the employee or former employee has the opportunity to still take it further, and it's called a right to sue letter. So they can request a right to sue letter within 90 days of this finality of the charge, and they get to float that around for 90 days to seek counsel who might want to take you civilly to court. That's really a rare event when they lost with the EEOC. So I just want you to understand the process. Now, also understand this, and I know I'm looking at my time a little bit, is that if an employee leaves you and says, I'm going to sue you for this, they still, before they can go get an attorney, but even the attorney knows I can't take you to court immediately. If it's based on one of these protected statuses, we have to go through this administrative process through the Virginia Human Rights Commission and or EEOC or both to get the clock rolling. Okay. So the charge is a document. It's called the EO Form 5 that comes across. You'll get it, and it's sometimes very basic with 2 paragraphs. 1 paragraph, I worked on this date. I was discriminated against. This is what occurred, and I believe it's a violation of Title VII based on race or disability and the like. Okay, it is under oath. And I'm going to tell you, even though it's under oath, I've seen so many that are fraudulent. And I could spend an hour and a half with you to talk about some of these that almost seem. I've had the accused say, can I sue because this person called me a racist? And they said things that were vile. And actually, there's protections there that don't allow the individual to sue because it have a chilling effect on the process. But it's unfair. So who can file a charge? Well, obviously, the person that's aggrieved, but others that witness it, they can do it on behalf of individuals. It's a rare event to see it that way, but they can. And again, I've talked about the 300 days versus 180 days. Just know 10 months is really the piece. Okay. And the ESC is required to provide notice of charge to the employer and named in the charge that outlines the date, place. So they are required to do that. Talking about this process a little bit. So the first step in responding to a charge is kind of like the internal investigation, is let's assess our risk. Are there legs to this thing? Did we do something wrong? Did we have an employee do something wrong? We're going to conduct an internal investigation very quickly. It may be loosey goosey, but we want to know what's going on. And then do we need to bring in other folks? Are there multiple charges of the same incident? Are there inflammatory charges? Are there flashy or newsworthy charges? Or are they just really legitimate? Just like the internal investigation, what's the character of the individual that's bringing the charge? It's a former employee that was disgruntled. They stole from the company. Well, we know what the character is. Okay. Now, understand this in the process. So you get the charge of discrimination, and they say, well, you can mediate or you can provide a position statement with all of your information by a due date, typically 30 days. Okay. And y'all sat on it for 2 weeks, kind of thinking about it. And now you're down to 2 weeks left in the 30 days. And you decide, no, we don't want to mediate this. And now I've got to pull it all together and develop a pretty professional position statement. You can ask for an extension. It's almost automatic these days, but you have to put it in on the portal. And so if you ever get into this bind, it's a pretty simple letter to them. So we need to, and they're only going to give you 2 weeks. So understand that you have some time to really evaluate this. Okay. Charges of discrimination may be settled any time. So understand, and I've gotten on the phone before with the individual, the investigator, to say, listen, let's just cut to the chase here. What do they want? And they may or may not disclose, but they're like, well, they feel like they need 2 years pay, and say, well, we'll give them 2 weeks. Well, can you take that back to them? There are opportunities in this process, and the ESC actually likes to tie these or button these up as quickly as possible. But understand that anything that we do, there would be a settlement agreement where they hold you harmless moving forward and avoids litigation. Now, that said, I mean, sometimes you don't want to give a dime to these people. You don't want to mediate, and you'd rather pay the money for counsel, regardless that you could settle for less than what counsel costs. And I get that. There's a principle involved. So each case stands alone here. Okay. I mean, I was in Richmond, I don't know, probably 12 years ago with a long-term care facility where we knew we had a young pregnant woman working for a long-term care community that was a CNA that could not lift, could not do her job, and she was in her pregnancy, and she was restricted from doing her job. They didn't have any light duty, so they sent her home. Perfectly legal at that time. I was freezing downtown Richmond, meeting with the company and the mediator, and she knew that we were right. She knew the company was right. But the girl literally was going to have her baby within 2 weeks. It was December 27th. We gave a little bit in mediation. Begrudgingly, gave her 2 weeks. She signed off on it and was settled. Okay. They certainly spent more on SESCO to have me come from Bristol or Richmond and spend the night. So you get the idea. So conciliation is the piece I'm talking about. It's a voluntary process where we can just simply sit down and say, let's talk about this. It can happen during or at the end of the process. Okay. That we will negotiate terms without going to court in this process. Okay. And I won't get into all that. So the key ingredient is, again, preparation. First step is in the investigative process is document review, personnel history, and interviews to clarify what's going on. Now, with that said, one of the things I need to point out is the first question I get is people call and say, Joel, I got this charge. Can I send it to you? Sure. Can you help? Well, yes, we can help. But and we still do it, but most of you all have employment liability insurance now. And begrudgingly, I'm going to tell you that you need to reach out to your carrier first. And once you have an EOC charge in front of you, that's when it's actionable by the carrier. And they may assign an attorney to you. Your deductible comes into play. So, for example, I might be able to really work through this process pretty quickly at a reasonable charge versus maybe an attorney out of Richmond or Northern Virginia. But if it goes catastrophic and you didn't avail yourself of the policy, even though Joel did a good job, you don't have the insurance potentially to cover for it. So, so that's the first piece. When you get an EOC charge, let's look at our avenues of protection here. Okay. All right. So position statement, if you're running it on your own, um, determine who's going to write the statement and what the response is going to be. Again, if you're a small employer, you may not have that capacity. I've seen them as simple as they just sent a letter in with some basic bullet points of 2 pages, which I would never think would be a great position statement, but they passed with flying colors with the EOC, where they found no reasonable cause of discrimination to occur. So you have a central theme. You want to keep it simple and clarify actions, what happened, make sure it's accurate and complete. Don't get into opinions and this person was, defamation about the individual unless you can support it. Just the facts. Okay. Remember, this information is foilable. And in fact, your position statement will be made available to the charging party on that portal. And then they have a chance to rebut. Now, their rebuttal, we don't get a second chance to rebut. So they allow the employee to rebut one time, which is atypical. Okay. When the OC charge has been filed against the organization, again, you got to retain all your records, text messages, emails. If they have an attorney involved, they'll let you know that you need to do that. But these records should be kept until the bitter end and the charge or lawsuit has been expedited and closed. Okay. Appealing a decision, if the charge was not dismissed by the EOC, there are means, some basis for proceeding for further investigation. You have to be able to prove more information that's different than what was not included, and that can be a challenge and burdensome. Okay. So again, provide complete and accurate information that's got to be new in the charge, appealing the charge. Again, the average time, it depends. It depends on the type of charge. But 182 days is the average, what the EOC says. I've had them that are resolved in 1 month, 3 months. I've had them go to 18 months. Um, so if an individual again wants to sue you, they're going to be sitting out there for quite a long time going through the administrative process. If you have concerns regarding the scope of the investigation, the investigator's going down a path that you're like, this has nothing to do with this charge. You need to have a discussion with the investigator and or counsel. Okay. So again, remedies for this may include compensatory or punitive damages. Again, remember what my statistics were, that it's going to be a rare event to begin with, even to go down the path of going to court. There are limits on compensatory and punitive damages, and there are liquidated damages for age and sex discrimination. I'm not going to get into all of this. You all see some crazy numbers that come out of Hollywood, and somebody wants 40 million for sexual harassment. Well, in the real world, that's not what occurs in business. It's typically it may be loss of income while they're not working for the company. It could be a payout of future, if you don't want this person back, back wages, future wages, and the like. Still be very expensive, but that's if you have the employment liability insurance, that is a piece that they'll negotiate. They have risk management on this. Okay. So this is the last slide. For management, tell your employees that if someone complains about their behavior, they need to stop. Okay. If you spot it, stop it. That's my number one thing when I'm doing harassment training. It's so easy for a good frontline manager to say, this is not how we conduct ourselves here. If it comes forward, conduct prompt, fair, and complete investigations, walk through the processes, come to a conclusion. If there's been a violation of policy or law, take action to remedy any harm and prevent any further problems. If it's serious misconduct has occurred, take disciplinary action. So again, it can be from education to termination of employment. Yeah. So, I mean, I guess to close this out, from my perspective, is just know that through your relationship, you can reach out to us and ask us questions on these things, or something pops up and say, let's just get a second opinion. We think we're doing the right thing. And we may tell you you're doing the right thing. It happens all the time where people just want that little bit of acknowledgement. So again, I'm Joel Cullum, Senior Vice President at SESCO, and I hope you've enjoyed this piece. I'm going to stop sharing and see what kind of chats or questions we have. Lauren, you there?
Yeah, at this point, everyone, if you have a question, feel free to put it in the chat feature. We'll give you all about 1 to 2 minutes to do that.
I know it's a lot to get through.
All right, it looks like we don't have any questions that came in, but if you do have any questions, okay, we have one question. So Russell said, Joel, in your experience, when have you had to get law enforcement involved during an investigation?
Okay, that's a very rare event. Honestly, law enforcement, in my experience, is usually when there's been an assault has occurred. And again, I've been doing this a long time, and I've only seen police called or law enforcement called a couple times. I guess it depends on how egregious it is. Sometimes I don't think they should have been involved. I had one, Russell. I don't know if this is a good answer or not, but the I had one where a manager of a restaurant took a photo of one of his young coworkers from behind. He thought her jeans looked good on her, and a patron in this restaurant saw it, and she called the police. And the police came in and actually took his cell phone. It wasn't against the law necessarily, but if there's assault, yes, but I wouldn't have. It's really up to the charging party or the individual. If they felt that they've been assaulted in some way, they can certainly contact police on their own. Okay, that's where I take it. I don't know if that answers it. If you want to reach out to me personally, feel free. Uh, Tracy, what do you find is the biggest mistake an organization makes with an EOC complaint? The biggest mistake is not taking it seriously and not being timely with it. These are disruptive unto themselves to go through the process of interviewing people and developing a position statement. And the EOC at times can be stilted depending on which office they're coming out of. I mean, I've seen them where they have already made their opinion without even getting your side of it. So it's a piece to work with. But that's the biggest mistake is not addressing it immediately. Okay, it's not about mediation. I'm not a huge fan of mediation, but others are. I like if you're holding to your guns and you really believe you did the right thing, then we provide a position statement. Okay, and we don't settle. But then again, you're if you go through your insurance, they may say we're going to settle, and that's a difference. So what's the difference, Chris? What's the difference between a settlement and conciliation? Really, a settlement, they're kind of the same thing. Conciliation is just we can pick up the phone during the process to say what can we do to make this go away. Okay. And the settlement really is at the end piece where we know. I mean, it's called a conciliation agreement at the end, but it's similar in nature. So I don't know if I'm answering the right way. It's one's kind of during the process and one's at the end of the process. Uh, I got it, Russell. Had an embezzlement issue that we had to call law enforcement. Of course, yeah, certainly. If you have something like that, I appreciate that. I would call immediately. And not necessarily everybody does that on embezzlement. They try to handle it internally, but it depends on what was embezzled or stolen. Okay. Anything else?
All right, if there are no more questions, thank you everyone for attending. Thank you, Joel, for presenting today. We really appreciate it. And
Yep.
I will send out the recording to everyone shortly. Have a wonderful afternoon.
Thank you, Lauren. Thank you, everybody. Enjoyed it thoroughly.